Hello friends, today we are recording this video for understanding a very important judgment very recently pronounced by the Honorable Supreme Court on 12th of January 2022 in the case of Assistant Commissioner ST and others versus Satyam Shivam Papers Private Limited and others. So friends, this is a very welcome judgment, I would say. The reason being that since last almost 3.5 years, since the day when e-way bill was introduced, the department officers have started taking the assessees on ride on a regular basis. Without going into the genuineness of the transaction, they simply concentrate on detention of the conveyance as well as goods for reasons which are beyond their jurisdiction. For example, the valuation, for example, the description of goods, the HSN classification not correct. As per law, the purpose was that whenever the goods are in transit, the officer was at liberty under the provisions of Rule 138A that he can stop the vehicle, intercept the vehicle, and check the goods and the documents which was supposed to be carried along with the conveyance during transit. And those documents were invoices and the e-way bill. Beyond this, they were not having any jurisdiction that they can go into the valuation or they can go for any other merits. Simply उनको केवल इतना ही चेक करने का अथॉरिटी था कि ई-वे बिल और इनवॉइस जो व्हीकल के साथ होना चाहिए वो है या नहीं. अगर नहीं है तो 129 इन्वोक कर सकते हैं, अगर है तो नहीं कर सकते. There are a lot of judgments also pertaining to this issue. Now, in this case, which we are covering today, it was found that the goods were traveling from one place to another. But because of the traffic jam or the traffic blockage at Bashir Bagh, because of the anti-CAA and NRC agitation on 4th of January 2020, the e-way bill expired. So the facts of the case is कि एक जगह जब गुड्स ट्रैवल कर रहे थे, जब कन्वेंस मूव कर रहा था, तो ट्रैफिक ब्लॉकेज था बिकॉज ऑफ सम एजिटेशन which was beyond the control of the taxpayer. So e-way bill got expired. Now, since the e-way bill got expired, the goods and conveyance were intercepted and detained by the officer. The assessee tried to explain that this is not the right action which is being taken against him, but the officer refrained to consider all those submissions which were genuine to a large extent, because traffic blockage पे वो कुछ नहीं कर सकता था. Yes, he could have extended the time limit of the e-way bill, that he has not done, but at the same time he was genuinely submitting that because of this traffic blockage he could not reach the destination on time and therefore the e-way bill expired. The officer have not considered it, or the height of the abuse of power was that he detained this conveyance for 16 days at his place. He was keeping the goods at Sikandrabad in the house of his relative for 16 days, and he was saying that it is kept there for the safe custody. So the Honorable High Court of Telangana went into the matter. They have considered the submissions made, and they pronounced an order wherein they said that e-way bill could have been revived or extended, but at the same time, the officer must have considered the genuine submissions also of the traffic blockage and accordingly must have been acted. But nevertheless, the court said that the tax and the penalty, which was to the tune of 69,000, which was levied, was not supposed to be levied, and therefore the Honorable High Court of Telangana has set aside that order of the levy of tax and penalty, and at the same time has imposed a cost of 10,000 rupees on the respondent officer. 10,000 रुपए का उसके ऊपर कॉस्ट भी लगाया गया. Now, the matter went to the Honorable Supreme Court. The department filed the appeal, special leave to appeal, which was 21132 of 2021. Before the Honorable Supreme Court, the matter was taken up for the hearing, and the Honorable Supreme Court was very annoyed, and they came down very heavily on such officer, that these officers are abusing the powers to a large extent. And the Honorable Supreme Court has increased the cost, which was 10,000 rupees imposed on the respondent officer or respondents, to 69,000. That is the equivalent value of tax and penalty. And the Honorable Supreme Court has said that this amount of 59,000, that is 10,000 already High Court ne impose kiya tha. 59,000 was the additional amount which was imposed by the Honorable Supreme Court. So this 59,000, which will be over and about 10,000 rupees. And they have also clarified that the state would be entitled to recover this amount, this cost which is being imposed, after making the payment to the writ petitioner directly from the person who is responsible for the entire unnecessary litigation. So friends, this is a wonderful order, and this may give a lesson to such officers who are abusing their power. And we want such kind of orders by the Honorable High Courts and the Supreme Courts, wherein they need to impose the cost on such harassments being caused to the taxpayers. अगर हम टैक्स इवेजन के लिए गुड्स को मूव कर रहे हैं, then imposition of penalty under section 129 or confiscation fine under 130 is understood. But if it is not for that purpose, then imposition of 129 is nothing but abuse of power. बट कोई भी नहीं सुनता, और हर ऑफिसर जो एक बार आपकी गुड्स को या व्हीकल को इंटरसेप्ट और डिटेन करता है, वो 110% आपका 129 को इन्वोक करता है, विदाउट अप्रिशिएटिंग द एक्चुअल रीजन. और ऑनरेबल तेलंगाना हाई कोर्ट में जब ये मैटर आर्ग्यू हुआ, तो तेलंगाना हाई कोर्ट ने यही बोला कि व्हेन द रिस्पोंडेंट्स हैव सबमिटेड द काउंटर एफिडेविट, they have not placed on record even a single line saying that e-way bill expire और ये पर्पस था evasion of tax. Nowhere it is specified, nowhere it is mentioned in the affidavit in reply submitted by the respondents that this was for the purpose of evasion of tax, या वो किसी दूसरे व्यक्ति को ये सेल करने वाला था. That was never alleged. So since the respondents have had no case, but it was merely the abuse of the power, और 16 दिन अपने रिलेटिव के यहाँ रखना is certainly not acceptable. So I have shared this judgment for two purposes. One, for updating the listeners about the judgment of this Honorable Supreme Court, which can help us now to defend our cases pertaining to 129 or detention of the goods and conveyance. And two, that we all must take up this issue. And whenever we face any such kind of harassment, we should be strong enough to put forth our submissions before the top officials, so that these officers who are empowered to intercept and detain the vehicle does not take the taxpayers on a ride, because no one should be allowed to abuse the power which is given to them. With this intention, I have shared this judgment. I hope this judgment will be helpful to all of us. One pager analysis which we have done will be sharing as a link. From that link, you can also download the original order of the Honorable Supreme Court, which can be helpful to you. Once again, I am mentioning the special leave appeal number of the Honorable Supreme Court. If you want to download this order directly from the website of the Supreme Court, you can do that, which is 21132 of 2021. 21132 of 2021. It was adjudicated and decided on 12th of January 2022. And the matter was Assistant Commissioner ST and others versus Satyam Shivam Papers Private Limited. With this, friends, I am thankful to each one of you for the patience hearing and giving me this opportunity of sharing my views. Thank you, friends. Thank you very much.